All right. Hi. I'm going to give you a quick idea of what we're going to discuss tonight, and I guarantee you're going to have fun. Oh, okay. Uh, so we're going to go through a lot of the basics of contracts, and once I do all of that, at the end, we're going to have a negotiation scenario where you guys are going to pair up and put everything that you've written in your notebooks to good use to kind of go through the whole process of what a contract is and how the negotiation works. So, these are the four things we're going to be focusing on as part of every contract: an offer, an acceptance, consideration, and performance. So I'm going to go into much more detail after explaining who I am. I'm a retired music and entertainment attorney. I've been practicing since most of you were born, definitely. 1978. Anybody? Yeah, long time. I was an arbitrator for the US Copyright Office, and I've handled arbitrations in trademark and business disputes. I've taught college and graduate courses in the legal issues in the music industry. That was at Loyola for 13 years. I've written textbooks on legal issues. I have a client in the Rock and Roll Hall of Fame. I have more than one client that they'll never let into the Rock and Roll Hall of Fame, even if they buy a ticket. Um, I've reviewed more contracts than anyone should have to, thousands of pages. So, what I want to do tonight is to get the basics of what to look for in a contract, what to watch out for in a contract, and to feel confident about going in and negotiating a contract. So, four essential elements. Basically, a contract is an agreement to do something. It's to undertake work or to buy or sell something or perform a service. That's Webster's first definition. There's a second definition of contract, too. So, what two people agree on can depend on who the people are. We'll get to murder for hire and the contract issues and that later on today. I'm not making that up. We're going to cover that. This is going to be so. We have an promise, a mutual set of promises. That's the basics of what a contract is. It's a set of promises. You do something. If you do that, I'll do that. So buy, sell, rent, act, refrain from acting. Now, these contracts allow a remedy under law, meaning you can be sued for not living up to your contract. That's essentially what the remedy under law means. So it all breaks down to three words from Roman law: quid pro quo, which means this for that. One party offers to do something, the other party responds, agrees to it, and they do what they have promised to do. Quid pro quo. So this is back to the four basic elements that every contract has in common. There has to be an offer, right? There has to be an acceptance of that offer, meaning, oh, okay, I understand what the offer is, and I agree to your offer. So it's, I accept your offer. The third thing, there has to be something exchanged. Lawyers call this consideration. Now, it can be money. It can be, it's the reason for the deal in the first place, the consideration. That's what you're swapping. That's the this for the that. It can be services, it can be money, it can be performing an action or refraining from performing an action. So, for example, blackmail. What's blackmail? That's a contract. And yes, the blackmailer says, if you pay me money, I won't act. So a deal can be A contract can be for performance or specifically not to do something. So it goes both ways. The last one, of course, is the performance. You need all elements to really have a contract. The most basic kind of contract, once you've defined the terms, and we're going to go into a lot of questions to ask to get the terms clear and to define the term. The basic one we see every day is for sale. That is an offer. So how do we accept the offer? We pay him money and we buy it, right? Offer, acceptance. Consideration is the money that we pay. Performance is when they wrap it up and put it in the bag for you and give you a receipt. Simple, basic contract. The whole thing about contracts is that we do them every day, all the time, since we were kids, and we don't really think about it. But going to the grocery store and buying groceries, that's a contract, right? It doesn't have to be this long document that's 90 pages long, but it's a contract. Don't get the contract negotiations mixed up with an offer. If you don't like the offer, you negotiate. And later on tonight, we'll have a lot of tools that you would use in negotiation. So you're not stuck accepting the offer. Well, maybe at the grocery store you are, but if you go over here to the French market and you want to buy some, fruits and vegetables, you can haggle with them. That's, offer, acceptance, negotiation. That's all part of the process. Acceptance is an objective act that says, yes, I understand what you're offering. I agree, and I'm going to act in a way that's absolutely clear that I'm accepting your offer. So, yeah, at the grocery store, I pay him money. That's pretty clear. I've accepted the offer. But at an auction, right, the auctioneer says, $50. Raising your hand means that you have accepted the price that the auctioneer put on the item that he was selling. So that's an affirmative act. It's very clear. You raise your hand, yes, and he goes, sold to the man sitting over there. It also indicates when you accept that you understand the terms. You know that you're buying the thing that's for sale. That's the other half of it. Now, when that doesn't line up and there's some sort of misrepresentation, we'll get into that later when there's problems with contracts. Before there's a real acceptance, you have to figure out, were the terms finalized? Did we really discuss all the bits and pieces and that's involved in the deal? And, usually the answer is no, because there's always more questions to figure out. Was it a full agreement on all the issues? And a lot of issues come up that we don't even think about. Was there a valid offer and acceptance? Was there consideration? Was something exchanged? Did somebody pay some money or perform some services, or like the blackmailer, not perform services to make a trade under the quid pro quo idea? Did they have authority to create a contract? I can sell you my car, but I can't sell your dog my car. The dog has no authority or capacity to enter into contracts. I don't think they drive many cars either. But okay, here's a contract when you were a kid. Mom says, if you eat your vegetables, you'll get dessert. Everybody's done that. But that's a basic contract. You have an offer from mom. Dessert. I will give you dessert if you eat your vegetables. So the kid has to eat his vegetables. That's how he's accepting the offer. Now, what's the consideration that goes back and forth? Well, the consideration for the kid in that deal, in the eat your vegetables contract, is, oh, he gets a bowl of ice cream. The consideration for mom is that her child eats a nutritious meal. So there's consideration. It's not money being transferred back and forth. She's offering him ice cream for the act of eating his vegetables, which he should always do all the time, whether or not ice cream is involved. So that's the mutual promise back and forth. Now, talking about consideration, this isn't a dollars and cents thing. This is the consideration for the mom is that her child eats vegetables. For the kid, it's ice cream. So the consideration doesn't have to be an equal exchange, because what some people value as family heirlooms may have absolutely no value to anybody else. So you can't say, oh, the value has to be the same. It's what the parties agree to. So Jack and the Beanstalk, right? He takes the cow to the market, but he sells the cow for a bag of magic beans. Nobody thinks that's a good deal. But in the fairy tale, it turns out he plants the beans and the giant lives at the top of the beanstalk. So it's what the parties think is a good deal, what the parties want to swap. That's the consideration. And a gift. A promise of a gift is not enforceable. Remember, we said before that a contract is a set of mutual promises that is enforceable. You can sue somebody for not living up to their part of the contract. Well, a gift has no second part of it. There's nothing in exchange. You're giving it away. You're not expecting anything. I think, hope not, but it is a gift. So that's not really a contract, because there's a quid, but there's no pro quo section. Nobody's, you might get a thank you note or something. So that's the first idea, the basics: offer, acceptance, consideration, the value that's exchanged, and ultimately performance. So I said before, there's lots of questions to ask. And you know that if lawyers are involved, there's always more questions to ask. I know I'm a lawyer. So here's a really simple contract. You would think it's a barter. I'll swap you 12 chickens and a pig for your cow. All right? That sounds simple and straightforward. A dozen chickens, a pig, cow. It's never that simple. We have to ask more questions. Why are you swapping this? Which chickens? You've got a farm with 100 chickens. Which 12 chickens are we talking about? Which pig? Which cow? When are we going to do this? Today, tomorrow, next week, next year? Do you drive your cow over to my farm? Do I drive my chickens and pig over to your farm? Is this a permanent swap or a part-time swap? What happens if the cow is pregnant? What happens if the pig is sick? So this simple barter, 12 chickens and a pig for a cow, isn't that simple. There's lots of questions to ask. So some of the basic questions. Who? Well, they're the parties that make the contract. You think that's pretty straightforward. And it is. They're the farmers. There's mom and the kid to eat vegetables. There's a used car salesman and the shopper who buys the car. But those are one-to-one deals, mom and the son, one farmer to another. You can also have a contract between a company or a group of people, like employment contracts, or two companies can contract with each other. Or you might have a contract between a company and an entire group of people, like a union contract. They have thousands of members of the union. So it's still a quid pro quo. It's still trading something for something else. Now, there's a third type of person that's involved in a contract that may be obliged to follow the contract, may get the benefit of the contract, that had absolutely nothing to do with negotiating the contract. The time this comes up most often is in copyrights, because copyrights will last for 70 years after the life of the author. Well, let me give you another example. All right, I sell you a building. I say, pay me this amount of money every year over the next 20 years. Okay, that's a pretty straightforward deal. People do that mortgage to buy a house. But I die before the 20 years. That doesn't get you off the hook. You got to pay my children, my heirs, and they benefit from the deal that I made. They may not even know about the deal that I made, but they have to perform it, and they get the benefit from it too. Why and what? Why do you want to do this? Who's heard of legal documents that start off with wherefore the party of the first part, hereinafter referred to as the party of the first part, does herenow say to the party of this blah, 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 blah. That explains to other people who weren't part of the deal what the whole deal is about. It's kind of the summary of it. It's like, oh, okay, the party of the first part is this guy. Oh, and he's doing that for this. Oh, I get it now. I understand the why of the deal, even if they weren't there in the room making the deal. But you also have to think, why should I participate in this contract? Why should I do this? What's the benefit? Remember, we're trading something of value for something else of value. So we have to decide why. What do the parties want? What are they promising to do? You need a description of the goods, the services, the consideration, which chickens, which cow, be very specific. And later on, we'll talk about how to be very specific in various contracts. Where's the promise to be performed? There are lots of contracts that state that may take place in any particular territory or any particular geographic boundary. So that's part of the deal too. Where is this all going to take place? Is it limited? Am I buying rights to something that's limited in geography? Like, oh, I have the right to set up a franchise restaurant in Orleans Parish. Okay. So I can't do anything in Jefferson or St. Bernard. So the territory is limited there. So you have to keep that in mind too. If there's a delivery, where do I deliver? To your house, to your warehouse? All these other things that you have to consider. Where's the payment made? Do you mail me a check? Do you give me cash? Do you hide money under the rock in the backyard? These are all things to think about. Now, when is the promise to be performed? Yeah, we could have a contract and I could do it today. I could rent an apartment from you and not move in until the first of next month. So we have a contract from today, but performance is next month. Upon a condition, like, oh, okay, if this thing happens, then we have a contract. That's what gambling is about. People bet, oh, this team is going to win this game by so many points. Well, they don't have any control over the teams. They play football and, like who won, who lost by how many points. That's all these betting apps. That's what they do. The same thing with a horse race. Nobody knows who's going to win the horse race. So you bet and you get paid if your horse wins. You have no control over that except, bribing the jockey, but that's a condition that's outside of your control, but it's still part of the contract. You're betting on the football game. You're betting on the horse race. You have no control over who wins and who loses. Last big question, how much? Are we talking about money? If so, are we talking US dollars, euros, Japanese yen? Are we talking ounces of gold? Are we talking a number of items? Oh, you have to deliver so many chickens, that was part of the deal. Or you have to deliver 100 pounds of flour. That's the deal, not 99, not 101, 100 pounds. Do I have to work a certain number of hours for you, a 40-hour week? Or do I just have to accomplish what you want me to do? No matter how long, it may take 40 hours, it may take 10 hours or 50 hours. We don't know. The contract is to have something accomplished, no matter how long it takes. How long? So when does the contract start? I said before about the lease. I sign a lease with you today, but I don't move in into next month. Or I buy something from you, buy a car from you. There's no commitment that I buy another car from you. I may want to, I may not, as opposed to a continuing periodic deal. Like, for example, a lease. All right, we can go month to month. Every month, I'm leasing this apartment. May, okay. June is lease. July. We keep continuing the same thing. Or there may be a time period. I'm going to lease this apartment for a year. That's how long. And then after a year, we might renew. We might not. We may renew for a year. We may switch to a month-to-month lease. Who knows? But that's one of the questions that we have to ask about how long. When does it end? If there are renewal options, I mentioned that. Is there some sort of continuing relationship? I've hired you to work for my company for how long? I don't know, to work for a year, work forever? That's something to be figured out. Marriage is a contract. And the only way that ends is someone gets divorced or someone dies. The life of the copyright, I mentioned that before about contracts that may benefit someone that had absolutely nothing to do with the deal. It's a contract. The copyright lasts for 70 years after the death of the author, which means that the author's children, grandchildren, great-grandchildren are all beneficiaries of the deal. Likewise, the company that made the deal in the first place, they still have to pay the children, the grandchildren, the great-grandchildren for the 70 years. Now, if that company that made the deal gets bought out by another company, they're on the hook to pay the children for 70 years and the grandchildren and the great-grandchildren. None of the people after 69 years had anything to do with the original deal, but they're still obliged to live by it. All right. Performing what's in the contract isn't always possible. If one party doesn't perform, the other one doesn't have to. There's no quid, there's no pro quo after the quid. So like I said, it's a set of mutual promises with consideration, offer, acceptance, consideration that gets traded, something of value, and then finally performance. So in a situation where one party doesn't live up to it, there's no contract, they haven't performed, and they can be sued. So that's a breach. That's a violation in the performance or failure to perform. without excuse or justification. So let's talk a little bit about defenses or excuses. The contract is illegal. Godfather, I know we had a contract for me to kill that predetermined victim for a price. I didn't kill him because murder for hire is illegal. Not obliged to continue the contract. Unconscionable. Murder is immoral and unconscionable. That's why I didn't shoot the guy, even though we had a contract for me to shoot him. Duress. I only agreed to shoot that gangster because you were going to kill me if I didn't. Fraud. You're not really a prince from Nigeria. You're not really going to put money in my bank account. This is all a scam. I don't have to do any of this. Misrepresentation. We agreed to swap chickens, but those aren't the same 12 chickens we were talking about. So I don't have to live up to my part of the deal. Public policy. It's against public policy for politicians to take bribe. That doesn't stop them, though. Capacity. I can sell you my car, but I can't sell my car to your dog. The dog has no capacity, so I don't have to perform. Or unauthorized. Maybe you had somebody from the company that you did a deal with, but did they really have the ability to sign a contract for the company? So what do? Most contracts have provisions to save the deal because you entered into a contract to begin with. So what do? There's regular clauses in extensive long contracts to say, hey, if you didn't perform, I'm going to give you a warning. I'm going to let you know that those weren't the same 12 chickens. So you've got some time to give me the same 12 chickens before I sue you. Or there's penalties like credit card charges for paying late. Or you rent an apartment and the landlord says, the rent is due on the 1st and it's after the 1st. The landlord comes back and says, in our contract, we said you had until the 10th of the month to pay. It's the 9th, you better pay. So there's a provision to save the deal. And the same thing with arbitration and mediation. Mediation is where a third party tries to get the people on either side of the contract together. It's like a marriage counselor. They talk to, what do you want? Back and forth, try to save the deal. The arbitrator is like a mini judge. Each side presents their evidence, and the arbitrator makes a decision. Or you can always just walk away or sue. Module 2, ask questions. Because there's more things that you've never thought of that are going to come up all the time. Now, why contracts go bad? It all comes down to 2 reasons: greed and vague language. There are greedy people in the world. You don't want them to be, but they're greedy people. A leopard can't change its spots. Greedy people are not going to be not greedy. So how do you protect yourself? You have to be conscious of that. You go, I'm going to make a deal with this guy. It's all going to be great. Yeah. And part of you has to step back and say, wait a second. I just met this guy. He may want to take me for a ride. Who knows what's going on? I have to be very protective of myself by using language that is not vague. every clause should be absolutely clear with no room whatsoever for different interpretation. So what we have to do is define the terms ahead of time. We have to think about scenarios. What happens if the pig is sick? What happens if the cow is pregnant? We're going to anticipate these problems and then have a process to fix the problems. Okay, I'll give you a little scenario here. The teenager comes to the neighbor's house and says, I'll cut your grass for give me $20 when it's done. Like, okay. And the homeowner says, all right, go ahead, do it. So the homeowner comes out later, and yeah, the grass is cut, but it's still on the lawn. It's not raked up. So he says, wait, I said cut the grass. And the kid says, yeah, cut the grass. There it is right there on the lawn, right there. So no. You got to put it in a bag. You got to rake it up and put it in a bag. Kid says, that wasn't part of the deal. You wanted me to cut the grass. The grass is cut. You got to pay me more if you want me to put it in a bag. So the homeowner says, yeah, all right, put it in a bag. You think that's all? No, that's not it. So the homeowner comes out later and says, wait, the grass is, you picked up the grass. Now you got to put it in the bag. All right, but the bags are still on my lawn. You got to put them out for the garbage man to pick up. And the kid says, wait, you told me to cut the grass. I cut the grass. You told me to put it in the bag. I put it in the bag. We never talked about putting the bags out on the curb for the garbage man to pick up. So the problem here is that no one has defined the terms cut the grass. Because what the homeowner was thinking and the teenager were thinking, two different things. So you've got to think of what the other guy understands. You've got to use absolutely clear language. I want you to cut the grass today, this grass right here, this territory of my front yard. I want you to pick up the grass, put it in a bag, put the bags out on the street. So it goes on forever unless you start being very clear about your language. Everything would have been easier if both sides understood exactly what cut the grass meant. So in contracts, lawyers have sort of a trick to define terms. They use capitalized terms. And when the words are capitalized, they have special meaning in the contract. Now I'm going to show you something that is a real clause from a real record company. And it's so weird, I'm just going to read it to you. If company couples video songs with video songs which are not video songs hereunder, then the amounts otherwise payable to artists hereunder with respect to such coupled video songs shall be multiplied by a fraction, the numerator of which is the number of video songs involved, and the denominator of which is the aggregate number of video songs, including video songs involved, and each selection embodied in each video song and video song involved shall count as one video song or video song for such purposes. Right. Who is not confused? All right. If you notice, sometimes the words video song here in red are capitalized because elsewhere in the contract, that was a defined term. So I'm going to read it again. It's still going to be obscure, but if company couples video songs with video songs, which are not video songs hereunder, then the amounts otherwise payable to artists hereunder with respect to such coupled video songs shall be multiplied by a fraction, the numerator of which is the number of video songs involved, and the denominator of which is the aggregate number of video songs, including video songs involved, and each selection embodied in each video song and video song involved shall count as one video song or video song for such purposes. It's still unclear, but if you figure out, oh, you're creating a fraction that you're going to use to divide the royalties. So the artist who signs the deal, his video songs are capitalized. Other people that provided video songs that aren't part of the deal, their video songs are not capitalized. So this is saying we're going to pay you a fraction, pay the artist a fraction for the video songs that he does, not any other video songs involved. So you look at it and go, well, wait, I did fractions in fourth grade. Why don't you just say that? Well, there are lawyers involved. That's the problem. A verbal deal isn't worth the paper that it's not printed on, right? Everything that we talked about video songs capitalized and video songs not capitalized, if you don't have it on a piece of paper, you don't really have any way of proving that there was an offer, that there was an acceptance, that there was consideration in the deal, or there was performance. It was like, oh yeah, we had a handshake deal. He said it was going to be okay. Yeah, that never works. Look, I've been in the music business a long time, and there's so many, oh yeah, talk to the guy, it's okay. No, it never works that way. So the lesson for module number 3 is to be precise in your language. I know you don't want to be. It's a pain, but you're going to have to do that. But there's some easier ways of doing it. And that's when we get to boilerplate. Everybody signed a contract, and there's pages and pages of fine print. Yeah, they're like font size of 5. It goes on and on and on and on. And you go, yeah. But basically, the fine print is there in the contract for protection. That's why they call it boilerplate. It's in every single contract. So here's some of the boilerplate you're going to run into all the time. It's the entire agreement. What we've written down is the entire agreement. Doesn't matter what the salesman said. If it's not written down on the piece of paper, it's not part of the deal. All right? Modification. Translation. If we change the deal, both of us have to sign and approve the change. You can't just say, oh yeah, it's okay if you do that. Well, that changes the deal. I want it in writing. Define terms like territorial limits. You go, oh, all right, I understand. You're going to cut the grass in my front yard. Yeah, all right. But what if there's some sort of international deal? Like in the record business or the film business, you say, oh, okay, I will give you distribution rights for the United States. You can distribute this record in the United States, or you can distribute this film and play it in the United States. And you go, oh, all right, I see that on the map. But does that include Puerto Rico? What about Guam? And what about, U.S. embassies in other countries? People consider that part of the United States. That's where the ambassador lives. What about American ships at sea? What about the International Space Station? And you think I'm making that up? No. I've dealt with contracts where they specifically say, you have the distribution right on the International Space Station or any other space programs that go to the moon or whatever. It used to be that you'd have worldwide rights. In 2 or 3 years, there's going to be astronauts living on the moon. Do those contracts cover the moon? Or are you going to have to add another clause and say, oh, so the way the lawyers do it is particular lawyer way. They say, oh, it's for the universe. forever. It's perpetual and universal. All right, to cover it that way. Act of God. This is a very important point. An act of God is something external that happens, and nobody that signed the contract has any control over it. But it's the external thing that happens that prevents the contract from taking place. So, you know, hurricanes, storms, natural disasters, wars, riots. Oh, I wanted you to deliver my pizza. Well, it's a hurricane. I'm not going to deliver your pizza. But also, it doesn't have to be natural storms and floods and hurricanes and tornadoes. It could be wars or riots or COVID, government shutdown. These are elements that are not controllable by the people that made the contract, but it's preventing them from doing the contract. This is more boilerplate. This is for the lawyers in the audience. Any lawyers in the audience? Yay, okay. Governing law. All right. If things go bad and I sue you, which courthouse do I go to? That's the venue. What address? All right. You live in Texas. I live in Louisiana. There's a problem. Where do I sue you? Where do you sue me? This is something that gets agreed on when you make the contract to begin. Also, location. I dealt with contracts in Kansas City, Missouri, and of course, right across the river is Kansas City, Kansas. So the question is, all right, which are we going to use Missouri law? Are we going to use Kansas law? They're just right across the state line. I know this because I live 12 miles from Texas. So the issue of law and venue comes up all the time for me. Exclusions. This is part of the boilerplate that clears out any doubt. I said before that you have to be really clear about what's included and what's not included, which 12 chickens, et cetera, et cetera. So disclaimers, I'll give you a translation. Disclaimer says what is specifically excluded. I'm renting you the apartment, but I'm not renting you the furniture. And by the way, you have to pay utilities too. All right, that's very clear. It's in the lease, it's in the contract. This is what you're getting. You're getting the apartment, not the furniture, and you got to pay the utilities. There are also formal statements of fact that one party wants the other to know, so the other party can't wiggle out. So, for an example, I told you this before we signed the paperwork. The house that I'm selling you, I own it. I'm not going to sell it to anybody else in the meantime. Also, I told you this before we signed the paperwork. The house is haunted, so you can't wiggle out of the deal. You can't say you didn't know because I told you the house was haunted. This is more boilerplate. The headings and agreements are usually not part of the contract. Invalid clause. If one bad clause can't spoil the whole bunch, like one bad apple won't spoil the whole bunch. Single for plural. Writers with an S. They're just like, oh, I don't want to have to retype the entire contract if the deal is with two people instead of one person or whatever. That's just a shortcut. Warranty and hold harmless. This is where the parties say to each other, this is usually mutual, saying, what I'm telling you in negotiating the deal is not going to change. I swear that I'm not lying to you. And secondly, the hold harmless is If somebody else sues because of something I said or did, and you have to go to court, I will pay the damages and I'll pay your attorneys, and vice versa. That's if we get sued because of something you did, you agree to hold me harmless and pay my lawyers and pay the plaintiff in the lawsuit. Okay. Notarized. You don't have to have a notary for your grocery store receipt. You have to have a notary to pass the act of sale when you buy a house because it's a public record. There's a notary and two witnesses. The same for writing a will and various other situations like that. The notary is the use of a notary indicates that these are real people that showed up and identified themselves. They're really alive and they appeared and signed the contract in front of the notary. And the notary signs off on that and then squeezes the paper with his seal. Anybody been to an act of sale? How many pieces of paper that you have to sign, and then they bring in the witnesses to sign here, sign there, squeeze the paper, because it's a public record. It gets filed in the courthouse. So signatures on a contract or document, they're not ornaments. They indicate that there was an offer that was understood and accepted by the other party, that there was some sort of consideration, no matter what, it might have been cash, it might have been acting or refraining to act. There was consideration back and forth. And the next step is performance for everyone to act in accordance with the agreement. So, yeah, signatures on a contract are the real thing. So, lessons from Module 4. Boilerplate is your shield. Okay, I'm going to take a brief intermission now. But I can start now? You can start now. All right, everybody's going to have fun. All right. That's my promise. That's my quid. And your pro quo is to have fun. So we talked about what you need to make a contract, right? Offer acceptance, consideration, and performance. And we talked about being very specific with the language and asking lots of questions, so important, and protecting yourself with boilerplate. Now we're going to get into the actual nitty-gritty of negotiation itself. It's all about negotiation. The basic underlying question is, how do we get the best deal? Because that's when you want the best deal. So it's negotiation that'll get you the best deal. But understanding and following steps and using tools will help you get the best deal that you can get. So this is a great book, Habits of Highly Effective People. So when you're in negotiation, you have to sort of begin with the end in mind, right? If the guy who paid the teenager to cut the grass if he began his contract with the teenager to say, okay, the end that I want to see is the grass cut, piled up in a bag on the curb. That would have saved all those problems. So sometimes you got to work backwards. You got to begin, but you have to have the end in mind. Next habit. You got to think win-win. I know that's a cliche, but you know what you want, what would be a win for you. Well, the other guy wants to win too. And negotiation isn't a situation where you beat up the other guy. You want to come to an agreement. They're giving value for the value that you're giving. So it has to be Mutual. A contract is a set of mutual promises. So you've got to think, all right, I've got a problem that needs to be solved. They must have a problem that needs to be solved. Otherwise, we wouldn't be talking. What's their problem? How do we solve it? How do we get to what could be a win-win situation? So to do that, first you have to understand what the other person is all about. What do they want? Why do they want it? What are the points that they keep coming back to when we discuss this? What are they saying? What are they not saying? Try to figure out to understand them. You have to understand them as best you can. So the first tool is your BATNA, your best alternative to a negotiated agreement, BATNA. This is all just common sense, but it's an easy tool to use. Your best alternative to a negotiated agreement. So how do you figure out your best alternative to a negotiated agreement? You have to go through and be honest and think of all possible alternatives if you have no deal. Then you have to rank them. Okay, what's the best possibility? What's the one I want to avoid at all costs? For example, if I'm looking for a place to live, as part of my BATNA, I have to say, oh, I want this apartment. But the next step is, well, if I don't get a good deal on this apartment, there must be another apartment in the same neighborhood for about the same price. I'll use that. Or there's another possibility. I could get a roommate and we could split the rent. Or I could go back and live with mom and have to eat my vegetables. Or I could live in a car under a bridge. That's a possibility. You want that at the bottom of the list. But you have to be honest with yourself to list all the possible alternatives, because at some point in the list, you'll say, instead of doing alternative number 5, I will walk away. So you've got to know your walk away point at some point on your list of alternatives. You don't want to be living with mom and eating your vegetables, but it still has to be on the list. You got to be honest with yourself and think about that. So back to the vegetables and ice cream. What's the BATNA here? The BATNA for the kid is straightforward. One alternative is he refuses to eat his broccoli. He gets punished. He gets sent to his room, and he doesn't have any ice cream. So if he would rank them, it's like, I don't want to be punished. I don't want to submit. All right, yeah, okay. I'll eat the vegetables and eat the ice cream. That's his best alternative. You think he may like vegetables. Who knows? All right, so you have to go through and figure your BATNA, deal or no deal. And as part of the things that you have to consider in your alternatives, you have to consider what are the costs of having a deal or not having a deal. Like, okay, like with the apartment. All right, there's no deal here. What are the alternatives? What are the costs? What options are left to you after everything? Can you get what you want without this particular deal? You go to a car dealership, you don't like the deal, you go, well, I can go to one across the street and buy their car. So you got to think that that's part of the alternatives. You put it on the list. How much money, the finance terms, et cetera, et cetera. Well, there's an alternative across the street. What would you lose if there wasn't a deal? And this is something that's going to come up in your negotiation scenario in a bit. Maybe you want to buy something, but the price is high. Is there somebody else that sells it? Is there an alternative? Do I have to buy this? This deal isn't working. I have to think of other alternatives. Or is this a deal that I need for something else in the future. I need this deal because it will lead to something else in the future. So that's on your list of your BATNA there. And then you got to think, what's the least you'll take before you walk away? It's okay to walk away. It happens all the time. You don't, just because you're negotiating with someone, you don't have to sign a deal that you don't like. You can walk away. You have the option to walk away, but also you got to think about the other guy's point of view. You've got your strong BATNA. You've listed all your alternatives. It's like, okay, if I don't get this apartment, I'll look for an apartment in the neighborhood for the same price, or I'll get a roommate, or I'll live with mom. And you've got all your alternatives. But the other side has a BATNA too. What are their alternatives? Do they need to rent this apartment, or do they not, or whatever? You've got to kind of think what they're looking for to figure out their BATNA. But if you have a good idea of your negotiation priorities, you're much stronger in the deal. Okay, here's some things to keep in mind. You got to be perceptual. You got to figure out what they want. It's like, okay, they want so many dollars for this. Like, okay, I understand that. That's a fact. But what do they really want to do? The car salesman wants $30,000 for this car. I understand. Yeah, that's money. That's a fact. But why now? Why today? Is he at the end of the month and he has to have a quota? Oh, never thought about that. That's a possibility. That could be motivating him. Did his boss yell at him for not selling as many cars as he should have? Well, that's a possibility. Does he have tickets to the big game that he bet on and he wants to get out and go to the game? That's a possibility. You got to figure out more than just facts. You got to be pragmatic, not emotional. Who wants to deal with someone who screams all the time? Nobody. Because you want to be cooperative, because you may have to do a deal with them in the future. You don't want to burn them and leave a bad taste in their mouth when you do the first deal. So, like Confucius says, you have to be firm and correct. Polite, like, there's nothing personal. We're negotiating a deal. Offer, acceptance. Let's see what the terms are. You have questions. I have questions. Let's define the language. So that's all about creating rapport, which leads to the next magic word, your ZOPA, your zone of possible agreement. What do you want to achieve in your deal? What do you think the other guy wants to achieve? So one party, represented by the green arrow, wants money, 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 or they'll walk away. And the other party, represented by the red arrow, wants it for free and pay zero, or else they'll walk away. What's the overlap? There has to be some sort of overlap. Otherwise, the two parties wouldn't be discussing a possible deal in the first place. So it's your job to kind of figure out that overlap. What is the zone of possible agreement? It may be money. It may be something else that isn't money. It may be who knows what. And when you do the scenario with the opera singers, there's a lot of non-monetary things to think about as part of the deal. We've all signed bad deals. I don't want to bring up bad memories, but we've all signed bad deals. And it's because we never knew the steps. We never knew about the tools of, the BATNA, the walkaway point. But think back on a deal that you entered, whether it was a good deal or a bad deal. What was your strongest point? What was your weakest? What was the other guy's strongest point? What was the weakness? You got to put your brain into their brain to figure it out. Now, here's another word, the anchor. The anchor is the starting position in the process of negotiation. Once someone names a price, that price is anchored. If the anchor is in the ZOPA, the zone of possible agreement, all right, you have something to work with. Or like you say, yeah, we're going to pay money for this. It's just a question of how much. Here's the maximum, here's the minimum. Maybe we can have something that overlaps. But if the anchor price is way out of line, the other part will go, why am I even talking to you? You have no idea. You have no idea.
Common pitfalls. 1. Don't negotiate. Explain the value of what you're offering. 2. Don't negotiate with yourself. That's the other guy's job. 3. Don't accept the first offer. There's probably a better one coming. Be careful. Win-win. Mutual gain negotiation focuses on the idea that it is possible for both sides to exceed their BATNA. More common pitfalls. 4. Don't make the first offer, if you can help it. 5. Listen more, talk less. You can't say the wrong thing if you're silent. 6. No free gifts. Give value and get value. 7. Avoid slicing up the deal. Quote the total price. 8. Avoid the rookie's regret. Know the cost and value of your offer and what you want in return. 9. Avoid the quick deal. If they want you to commit quickly, it's probably a mistake for you. 10. Never disclose your bottom line. It will turn a win-win into a lose-win situation. Thank you for viewing NOTCF's Elevation Series, The Art of Contracts and Negotiations, in partnership with the Ella Project and the New Orleans Jazz Museum, presented by Mark J. Davis, Esquire.